Thank you. May it please the court, good morning. I'm Steve Sen, here as counsel for the appellant, Sally Bell, here with my law partner, Kevin Ashley, also counsel for Ms. Bell. With the court's permission, I'd like to reserve 5 minutes for rebuttal. Sally Bell's daughter, Kristin Wiesen, died as a result of medical negligence. She left behind a husband of 3 years and 2 surviving children who were not the biological or adopted children of the surviving husband. Bell was appointed by 2 separate courts to serve as the guardian of the property of her children, of her grandchildren rather, and on this appeal seeks review of orders by the circuit court allowing recovery of attorney's fees in the amount of $3.9 million without allowing an evidentiary hearing as requested by both Ms. Bell in her capacity as guardian of the property and as encouraged to the court by Alan Gassman in his capacity as a specially appointed guardian ad litem for the children.
Mr. Gassman's function was purely to explore the manner in which the settlement would be structured as to that portion of the settlement going to the children, right?
That's absolutely correct, Your Honor. He was appointed for that reason. The trial judge was concerned that the form of the settlement structure that was being recommended by the attorneys for the plaintiff and by the guardian ad litems and their advisors was not in the best interest of the children, and so he sought additional guidance from that specially designated Mr. Gassman, who is well regarded on these issues, and Mr. Gassman did conduct a report to that regard. The judge wound up accepting Mr. Gassman's recommendations as to structure, subject to rather than having a payout over life, to have it a payout, I believe, at the age of 35. But in the course of conducting that, Mr. Gassman recognized this issue and felt it to be within the scope of his authority as an officer of the court, as a specially designated guardian ad litem, to bring to the court's attention that there are some legal rules dealing with attorney's fees in this context that had not been respected, and that the court should take opportunity to follow before the mule got too much farther away from the barn.
And Mr. Sen, which leads me to my question. Mr. Gassman was appointed after the May 15th hearing, correct?
Yes, Your Honor, that's correct.
All right. And much ado, we don't have a transcript of the May 15th hearing, is that correct?
That's correct.
And there's also acknowledgement that at least your client, Ms. Bell, was present at that hearing.
Yes, Your Honor, that's
not
correct.
Her counsel was not there, but she at least herself was there. So how do you respond to the other side's concerns, and actually a little bit of my concern as well, that at that hearing, there was a full determination made of everything. And at the conclusion of that, where we don't have a transcript, we don't have anything, there was no appeal, no objection of any type of attorney's fees or part of this was a global settlement. How do you respond to the fact that this is properly before us at this time?
Well, 2 things, Judge. One, and we filed a response to the court's inquiry as to a transcript, laying out a number of cases that say that you do not have to have a transcript if it is clear from the information that the court does have in the record that the procedures had not been followed. In fact, that exact, very similar situation involving our fact patterns is the Loper versus Apfelbeck case, where the court said we can't tell from the record whether the judge satisfied the judicial responsibility to ensure that the minor was fairly taken care of. In the Loper case, the court said, since this cause involves a claim of a minor, the trial judge has the discretion to reduce the attorney fee if such action is shown to be in the interest of the minor. Since we cannot determine from the record of the final order whether the trial judge has reached this issue, we remand this case for determination whether a contingent fee of 40%.
Everything before the trial court at that May 15 hearing, it included a settlement statement that reflected fees, correct?
Yes, Your Honor. That was submitted to the judge at the hearing, not before the hearing. And we have, there is in the record a verified statement of Ms. Bell that this was not brought to her attention until later on. And none of this had been brought to her attention.
There's a motion for clarification and the amended order, if you will, only deals with the notion of having Mr. Gassman come in to do a second look at the structure as to the portion to go to the minors, correct?
That's correct. The order does not say that the court has found that these attorneys' fees are reasonable and in the best interest of the children. That supplemental order does not deal with that. It simply says Mr. Gassman's position is the way to go.
And the order that came out of the May 15 hearing reserves a fee issue solely as it relates to the two guardians at Litem.
That's correct, but the court expressed at least twice on the record after that hearing that the trial judge had not considered that issue to be finally and dispositively resolved. In fact, he said in denying a motion for rehearing that was filed as soon as Ms. Bell was able to review these issues with her attorney, she then filed a motion for rehearing and an emergency motion for rehearing saying that we're just finding out about this fee stuff for the first time, and that needs to be resolved based on the Nixon case and the Bunkayo case and the other cases that have been filed. The judge then denied it, not because we have fully and finally resolved all of that. We've done all these things. What he said was, those are non-final orders. And then later on, at a hearing in September, the judge said, yes, I recognize that this is something that is supposed to be considered after the settlement. You guys see if you can resolve it by stipulation. If you don't, then you know how to set a hearing. So in the view of the trial judge, that was not finally resolved and could be subject to subsequent resolution. And the parties were led to believe that. There's a lot of, apparently in this court, a lot of practice is done by just sending letters to the judge, and there are a lot of these letters that are in the record that show that the parties continued to dispute back and forth over the issue of fees.
Let me back up a bit. In the motion for clarification, my recollection is that the PR was asking for a distribution. The court would allow distribution of everything except what would be left for the minor children. Is that correct?
That's correct, and we believe that that disbursement took place with the court's consent. The court, however, as I indicated, didn't seem to believe that was a final resolution of the issue. And these letters that I'm talking about, the parties continued to say if it is subsequently determined that the amount of the fees were excessive, those can be dispersed back into these trusts that we're setting up. So that continued to be a live issue all the way through until the order striking a motion for evidentiary hearing. The court had indicated that an evidentiary hearing could be had, and it was only the parties continue to operate under that assumption, as the correspondence to the court, which is in the record, will indicate. And it was only when the order striking the request for evidentiary hearing was entered that the parties then realized, oh my goodness, the court's representation to us that we would be permitted to set this for an evidentiary hearing if we couldn't agree. Apparently the court has reconsidered that, and the appeal was filed.
I wonder if you're overstating the tenor of the correspondence. It seems clear that one side to this dispute thought the issue was taken care of in May 15.
Well, they were making that argument, but they were also, and you're referring to plaintiff's counsel, also were representing to the court that, yes, you left that open for them to talk with us. We have provided them information. They have not been seeking additional information from us. Therefore, they're not engaging in the process that we think the court outlined for us to show them that our fees are reasonable. And, it's squabbling lawyers in letters talking about who is supposed to do what. But ultimately, they were, in some of their correspondence, telling the judge that we have not been getting the inquiries from them. We have not, they have not been acting in good faith to give us an opportunity to show them that our fees were reasonable. And the argument that ultimately came down, and the case law reflects, is that a fee that is in excess of the amount presumptively excessive should not be approved without an evidentiary hearing. That's exactly what a judge in this same court had done in the Chavez case that was brought to Judge St. Arnold's attention at the hearing. And that's when he said, yes, it appears that I'm supposed to do this after the settlement. And then more recently, we filed a notice of supplemental authority from a federal district judge opinion in February, where the request was for a 40% across the board. The judge said, hey, this is in excess of what is presumed to be reasonable, we're going to have a hearing, and you're going to have to convince me of that, because I have a duty, these judges are citing the same cases that we're citing in our briefs. And these trial judges are reading these cases as saying, I can't approve a presumptively excessive fee where a minor is involved unless I am shown that it's reasonable and in the child's best interest. That wasn't done here. We asked for that hearing. The judge indicated that hearing could be allowed, and once it was clear that the judge was not going to allow the hearing, we filed the appeal because we believe that hearing is required. And looking at the entirety of the record that is before the court, the fact that the transcript isn't present of that hearing should not be a barrier because, for example, if the judge had...
But if I may, Mr. Sen.
Yes, ma'am.
Because I know you make reference to a case that says, oh, lack of transcript, you don't, if it's evident in the record. Well, in this case, we have an order, an actual order that was prepared, order on plaintiff's motion to approve settlement. And in the order, it didn't say anything about there's still an issue of the attorney's fees, nothing. All it said, a hearing was conducted, and I think even the language, I've got the order right here, commending everyone and saying that the total settlement in light of the facts of this case, that the total settlement, and goes through that this is appropriate. And so we do have that. And
there's no challenge to the reasonableness of the settlement.
Oh, no,
There's nothing.
But I understand, but it also made reference to closing. There's all these documentation provided to the court, and in closing documentation, everything is placed in there. Not only the settlement amounts to the minor children, it's almost like a blueprint. Who's getting what? The attorneys are getting this, getting that. So I guess the concern that I have is that we have an actual written order where your client was present, nothing was done, no appeal of that order, nothing at all. Then later on, I think there's much to do about, well, the judge thought this, judge thought that. Respectfully, it doesn't matter what the judge thinks. We just have to deal with, and maybe sometimes in a case where the judge could be wrong, maybe at the beginning he's saying all that, then later on, when he ultimately granted the motion to strike, maybe he came to the realization, what are we doing here? This issue is dead.
Well, two things in response to that, Judge. Ms. Bell didn't do nothing. There was, as soon as she raised the issue with her attorney filed an emergency motion addressing this issue. Second, the order that you're referring to, nowhere in there indicates that the court undertook an inquiry as to whether the attorney's fees were reasonable and in the best interest of the children. The only
which begs the question that not having a transcript, who knows what's been stipulated? Who knows what was said to the judge? That this is the and throughout this whole case, it's very evident that these lawyers have done. Words were exceptional result. This was a case that was not touched upon by any other plaintiff's counsel. And we're not privy to that, so we don't know what has been stipulated, what has been done, and so that's where the concern is.
We know what the judge has said on that issue. The judge said that, yes, you're entitled to an evidentiary hearing. You've convinced me of that based on showing me Judge Logan's decision, and this is in September. You've convinced me that you're entitled to an evidentiary hearing if you can't reach an agreement based on Judge Logan's decision in the Shabbat's case. You can schedule that hearing if you guys can't agree. Now, if the judge had a full-bore evidentiary hearing and made that determination, then that would have been a silly thing for the judge to have said. He would have said, I'm sorry, counsel, you weren't present at this prior hearing, but we addressed all of that. That was all resolved. So I think the record is more than adequate to show that the court recognized that this evidentiary hearing had not been conducted, and there was no argument in the subsequent positions that was filed with the trial judge by the plaintiff's attorneys. What they were relying on for the reasonableness was a determination made at the outset of the case. This closing statement is in the record, Your Honor. You can look at it. It's not nearly as extensive as what you were stating. The amount of the fees, $3.9 million, is supported by a footnote that indicates that a contingency fee of 40% was approved at the outset of the case, January, when the complaint was filed by a predecessor judge. That is the extent of what the closing statement indicates. There were also certainly reports of guardian ad litem indicating that they thought the fee was reasonable. There was another report of another guardian ad litem saying you need to have these evidentiary hearings to make a determination of reasonableness. It's a question of due process.
No, and I understand that, Mr. Sen, but the way you're characterizing it, that the closing statement did not have any, there is a provision for fees. There is a recognition of that. And I guess I'm still struggling with the fact that I don't see how, quite frankly, we have jurisdiction in this case, because in looking at all the timelines, is that every opportunity for your client to appeal has not. And so that's the concern that I have.
Okay, well, I was responding to the merits. If I may respond on jurisdiction,
Yes, sir.
That's a very different level of response. The response on jurisdiction as to whether there is jurisdiction is that two things. One, the judge did not think that was a final determination because he later said it wasn't, and that he could have an evidentiary hearing. But more importantly, aside from that, generally attorney fee awards and cost awards are appealable only when they are issued post-judgment. If you look at the cases cited in our brief and in their brief, most of the courts talking about appealability of attorney's fees will include somewhere it's appealable because it's an attorney fee award that's post-decretal or post-judgment or words to that effect. And there are actually two court opinions that we have cited in our briefs that indicate that an award addressing entitlement to fees or costs prior to final judgment is not appealable.
What would the final judgment be in this proceeding?
Well, it's weird because of the way it unfolded. We don't have a final judgment. What we
Right.
do have is the judge finished doing all of the things that were kind of pieced out to be determined.
Right.
The final piece that there were, after the September hearing, there were two pieces that the judge said we need to deal with. One is we need to get to the bottom of the details on how this thing is going to be structured settlement-wise. That was later resolved by an order basically accepting Mr. Gassman's recommendation subject to a 35 years of age payout, and that resolved that. He said basically go do that, and that's how the settlement structure is going to be. The other thing that had been reserved, because the judge said on the record in open court that it could be scheduled later on, is this issue of fees. That other piece then did not get finally resolved until the order striking the request
Okay, but
for
going
attorney's
back to what
fees.
your argument is, which is that, hey, there should be a distinction between pre-judgment, post-judgment. I'm just wondering how that applies in this kind of proceeding. Was there, did we have an adversary proceeding that was going to go to a quote-unquote judgment? Or is this more just along the lines of the court's going to enter some orders approving of things?
No, what we have is the situation which, there's a number of cases cited for this, an order approving settlement agreement, but it didn't really completely approve the settlement agreement. But if there was an order approving settlement, that would have been,
So if I
in effect, the
understand
final
you right, you
judgment.
are analogizing the order approving settlement agreement to a final judgment for purposes of the case law that talks about the finality of post-decretal orders. Am I understanding your argument correctly?
That's absolutely correct, and that's what the cases indicate. There was a question at one point as to whether attorney's fees and cost awards, how are they appealable, what are the circumstances. That was resolved by a series of cases saying, yes, they are appealable if they are entered after judgment. If that's the only thing left before the trial judge, then they are appealable at that time because they couldn't have been appealed earlier, and so we're going to deem them to be appealable as final orders. And so where it is done when there's still, on an interlocutory basis, it's an interlocutory order. And it's not appealable, it might be appealable as an interlocutory order. Arguably in this case it may have been because it allowed the funds to be dispersed. It may be arguably appealable at that time on an interlocutory basis as an order determining the right to immediate possession of property, arguably. But the rule on interlocutory orders is very clear that just because you have a right to an interlocutory appeal does not mean that you waive your ability to appeal at the end of the case.
Mr. Sen, you're at 19 minutes. We have peppered you with questions. I'll let you keep your time for rebuttal, but just want to give you a heads up.
I appreciate it, Your Honor. Thank you.
Thank you, Mr. Sen. Mr. Elliott?
Thank you, Your Honor. Tom Elliott of Beal & Elliott here with my partner, Amy Ferrier, and with trial counsel seated behind us. I am tempted to say it is clear there's no jurisdiction. I get that from your questions, and just say nothing more.
Let me,
But
I don't want you to sit down yet.
no,
What does the notice of cross-appeal do, if anything, on the jurisdictional
the
point?
notice of cross-appeal.
Didn't you do a cross-appeal? some point? Okay.
There was another case.
Yeah, which has been
brought-
consolidated.
Yeah, and that case is gone because
Okay.
that was a case, I think, by one of the children who was no longer a minor, and that really didn't involve us. That wasn't even our fight.
Okay.
And I think the cross appeal was maybe brought by them in that case to try, in the hope of reinvigorating somehow the lost appeal, because it is clear they did not appeal in time. And let me go to that. Let me say, as an opening, that had there been less skilled lawyers here, they had gotten a $1 or $2 million judgment, and the plaintiffs, the beneficiaries, had gotten a much smaller recovery, but smaller percentage of fees paid. They would have netted a lot less. This was an outstanding result, and these lawyers are entitled to the fee that they contracted for, the fee that was approved by the court at the beginning, and it was expressly approved, contrary to what the reply brief says. The authority to represent is referenced in the in the 2016 order approving it. It is attached in the documents that went in, and it expressly is approved. So the suggestion that, oh, well, they didn't look at that and they look at the 40%, it's there, the constitutional waiver is there, everything was done correctly. Let's turn to what wasn't done, and that was an appeal in a timely fashion. The reply brief quotes from a case from this court called Hubert, and that's one of the cases they say, oh, well, you can only appeal these things after a final judgment, which, as Judge Lucas points out, there's no final judgment in this case. This case, there's no final judgment against Bayfront. It was a settlement. So there was never going to be a final judgment. The December order is no more a final judgment than anything else. So, but turning back to this, the Hubert quote is correct, but they've emphasized the wrong part. It's an order that completes judicial labor on that portion of the case. This is cited page 6 of the reply brief, and we cited it earlier. That portion of the case, the order, as the questions have already indicated, the court understands, the May order completely resolved the question of attorney's fees as to these trial counsel. To say, oh, it didn't really address it, it absolutely did. The court, first it says, I've heard, the court did hear from the guardians. The guardians ad litem that were appointed specifically for the purpose of protecting the children's interests and looking at this, who said, this is a great result, everything in here is correct. And the court has the closing statement. And it says, each guardian recommends approval of the distribution of settlement funds as outlined in the proposed closing statement. And that included the fees. And to suggest, oh, and maybe the court didn't see it because it's in a footnote, stop it. The fees were clear. So, that order, approving that is like an order, if you think about it, that's like an order dismissing one party from a case. Let's say you've got a case with multiple defendants, and there's an order dismissing one out. The plaintiff has to appeal that order right then in state court. You can't wait till the end of the case. In federal court, you could. But in state court, you've got to appeal that order right then. Same thing with a fee order. The two cases they cite are fee orders, and Mr. Sen said they talk about entitlements not appealable. I agree, entitlements not appealable. That's not what happened here. There was an order saying, this is approved, and that means you're going to get these fees. That's the result of that. Now, in fact, think about it this way. What if there had been an order sanctioning counsel in the case? During the case, it's not at a final sanctions with certain awards a fee against them. Do they have to appeal that then? They absolutely do, and this court has held that. And we can file that supplemental authority if you want. They absolutely have to appeal that. This is the flip side. This is an award to counsel during the case. These counsel aren't parties. It's an award to them. If somebody wanted to appeal that, they needed to appeal it. They needed to appeal it in the summer, not in December.
What do we make of the judge's comment about having a hearing, and what do we make of the correspondence going back and forth about the fee issue?
A couple things, Your Honor. First off, that comes up in a September hearing that is set for another purpose. And then the counsel, and just to be clear, Mr. Sen was not the counsel who missed the time for the appeal. That's somebody different. And he's not the counsel who made this statement. But at that September hearing, after Bell's lawyer says, well, the court approved the fee in 2016, including the constitutional waiver. I'm not going to speak to that. So that issue was gone in September. Now it's been resurrected, or attempted to resurrect in the brief, but it's been waived. At that September hearing, they're talking about the structure, and then he sits down and she says, oh, Judge, there's one other thing. You know, we think we should have a hearing, and kind of springs it on the court. No briefing, no nothing. And the court says, well, this was an outstanding result, but, why don't you all talk, maybe you can work it out, and we'll see if we need a hearing. It's in that context. When the court gets further briefing, when it actually gets briefing on it from counsel, the court goes, yeah, I'm denying this.
Might it be fair to construe the comments that were made by the court as sort of, it appears there's an issue rising up here that's bubbling up. Maybe I should send you all and see if you can't work it out so that we don't have to open this can of worms.
Absolutely.
Which is what trial judges do frequently.
And should not be penalized for it. And coming back to Judge Kuzam's point, it doesn't matter what the trial judge said or thought, because this court's Heyman decision that we've cited, a trial judge does not have the authority to extend the time to appeal. If that's a case, and the Heyman case cites a Supreme Court case, the court actually entered an order saying, you get more time to appeal. I'm going to extend your time to appeal. And the court says, no, you can't do that. You lost jurisdiction. I mean, if anybody was ever misled, it was the folks in that case. Okay? They can't come in and say, oh, well, the court didn't think it was final. What the court thought it was final, it was, and it wasn't final as to the structure. That's completely true. That's still to talk about, which explains the earlier comment denying it as non-final. But whether the court thought or didn't think it had to be appealed doesn't matter. It had to be appealed, and it had to be appealed before September. So nothing he said in September is misleading them. And again, you can't be misled. Like I said, the Heyman case, you have an order where it says, I'm going to give you more time, and that's not effective. Again, the December order, coming back to your point, Judge Lucas, December order is not a final judgment. This argument about, we can appeal after the final judgment, there's no final judgment.
One part of the jurisdictional question that I was kind of curious about, which is, and you just mentioned it now, about the structure of how this is going to be structured.
The structured settlements for the
right,
case,
which was still left open.
That's left open, yes.
Okay. If you read, and I'm not a big fan of pulling blurbs out of cases and just trying to take them out of context, but if you read the Mack case, which in turn cites to the third DCA case of Walker, which was an opinion that dealt with an order approving a settlement, and it says that the order approving the settlement is final where, and I'm quoting, there is nothing whatever for the court to do in the pending action other than to enforce what the order required of the parties. If structure of the settlement is still open, is there nothing whatever for the court to do other than enforce?
Only as to the form of the structure. There's nothing left. The fees have been approved. They've been released as they were in there's an instruction of the defendant. Pay everything but the structure to the plaintiff's counsel so it can be dispersed. And it is dispersed. And if somebody didn't like that, the time to appeal was by August 4th or 5th. We tracked the time, giving them the most favorable time. So yeah, the fact that there's something left to be done, again, that happens all the time in orders. There can be more than one final judgment, as we see. I mean, for example, the final judgment of sanctions against the lawyers. They have to appeal that then. They don't get to wait. The fact that the structure was left open, had the structure not been satisfactory to one of the two beneficiaries, they could have appealed that. Can they take that and say, oh, and we're going to reach back and grab these other earlier orders? No, and that's what the Mack case says. You can't reach back and grab those orders.
So it kind of depends how you cut the onion, right? I mean, if you consider that the leaving open the structured aspect of the settlement as being something, as kind of broadly speaking, in terms of how you categorize the order as, well, there's still something left to do, then it's not necessarily final. If, on the other hand, you slice it off and say, well, listen, the structured aspect is this kind of ministerial separate issue. The main part of what they're talking about is final, has already been decided. But if there were a further order on the structured part, that too would then become its own separate final thing. And I'm just wondering, why are we cutting the onion that way?
I don't, with all due respect, I don't think it's a cutting the onion thing. I think you look at it, there are separate pieces of a case. And you have to look at what an order does with regard to a particular piece of the case. And in the summer, the pieces other than the structure and the payment of the guardian's fees, those are the only two things left open. These are the only two things left. Everything else is done. If Bell had been unhappy with the allocation of the money between the husband and the two children, she needed to do that then. You couldn't wait until after you get a ruling on the structure, say, oh, now I'm going to go back and challenge this. I mean, their theory, if we bought into their theory, anytime somebody wasn't happy about a ruling and they missed the time for appeal, they would simply come back in front of the court and say, you know, I think I need an evidentiary hearing on that. And when that's denied, then you appeal that and you say, oh, now I want to appeal the earlier order.
Let me ask you, is there any set of circumstances that a subsequent ruling on the structure would have required revisiting the disbursements previously made?
Nope. Those monies were set aside. They hadn't even been paid yet. As you look at the June order, the court says, okay, hold, the defendant's going to pay all these other monies so they can be dispersed, and you're going to hold the structure money.
And there's no set of circumstances where that would require a redo?
No, because the structures are based on 1/3 each of the net to the plaintiffs, and those numbers are all set. They're set when they're approved in May by the court in the May order, which specifically says, I approve. You know, I've heard from the guardians, and they recommend approval of the distribution of settlement funds as outlined in the proposed closing statement, and then they simply go on to say, you know, the total amount will be remitted, is reasonable. Then he says, I have a concern about the terms of the proposed structured settlement. Proposed structured settlement is a separate set of money. That's the net to two of the three beneficiaries. I can talk about the other parts if you'd like. Do you have any question on anything else? This, with all due respect, is not even close on jurisdiction. There is no jurisdiction, as I think your questions have shown. We'd ask that you affirm. Thank you.
Thank you, Mr. Elliott. Mr. Sen?
To respond to a point made by Judge Lucas in citing the definition of finality as to when proceedings in the lower court are sufficiently final that they have to be appealed or they may not later be appealed. And that was basically the black letter determination when there is no final issues for the court to determine. That's partly why the issue of attorney's fees was kind of confusing before. Sometimes people would say, well, no, we still had the fee issue hanging out there, and so we didn't have to appeal the final judgment. And the law kind of got confused on that, and that's how we wound up with this issue of, no, you have to appeal a final judgment, and then if there's later a fee and cost award, that is a separate final judgment entered after the original final judgment on the subsequent issues, and so that then can be done. This idea that we slice and dice different issues before the trial judge, and some have to be appealed and others not beyond the fee and cost issue, is one that is alien to the idea that we're not going to have piecemeal appeals, that we're going to have a very discrete, defined area of interlocutory appeals that may be raised for various public policy interests, but we'll also put in there, again, because we don't want piecemeal appeals, that if you don't raise an interlocutory issue that you may, you can still raise it at the end of the case. You've not waived anything. So did Ms. Bell have notice that the judge had resolved all of the issues as to the fee issue or as to the other case? And the answer to that is clearly no, based on the record that is here. First, when he denied the request for rehearing, he didn't say, I'm denying it because we finally resolved that. What he said was, I'm exercising my discretion to deny these non-final orders that you're asking to be reconsidered, the order allowing disbursement. The court said that was a non-final order, and I'm exercising my discretion not to do it. If he'd have said that was a final decision, then certainly the parties would have been on notice that, okay, we have to do a notice of appeal now. But because he said it was a non-final order, I think any appeal of that would have been immediately dismissed because we'd be appealing something that right on his face says it's a non-final order. It would have been a futile act. They are arguing that we should have engaged in that futile act, and that because we didn't and because we waited until finality when the reserved issue on the question of how the settlement is to be structured and the separate reserved question as to whether there would be a hearing on fees or not, that is when the proceedings in front of the trial judge had finally resolved, when those two reserved issues, reserved on the record, the court suggested that the hearing was there and made clear that we're going to take a closer look at the structure. That's when finality occurred, and our appeal was timely filed at that point. There was another appeal. Somebody didn't like the issue on the structure of the settlement, and we did file a cross appeal on that. And that's another method by which this court could review it. There are also, we've cited writ cases, including this court's decision in Matheny, dealing with the issue of when a party can waive their rights to a presumptively excessive fee. In that case, this court said there needs to be an evidentiary hearing on that to determine whether that has been properly waived or not, and granted that by writ. And there are other cases involving both mandamus and certiorari dealing with the issue here. So in our briefing, we have laid out a multitude of ways by which this court should review the order granting a presumptively excessive and unconstitutional fee award in order to simply let the issue be determined at an evidentiary hearing to make a determination what is in the best interest of these children and make a determination what a reasonable fee is. The court indicated he would do that, and the court indicated that it wasn't going to be done. We then timely appealed as soon as it was clear that the issues had been fully resolved and that the court was not going to allow a hearing. We asked that the case be reversed and remanded for an evidentiary hearing. I thank the
Thank
court.
you, Mr. Sen. Thank you both.
Thank you.
That concludes our docket for this morning.